Namaskar. It's been 2 years since the NDA government under Prime Minister Narendra Modi took office. The government came in with the mantra of minimum government, maximum governance. And one of the ministries that has to deal a lot with governance issues is the Ministry of Law and Justice. And we are very privileged to have with us the Minister for Law and Justice, Government of India, Mr. Sadananda Gowda. Thank you very much, sir, for being with us. Firstly, let us look at, the government seems to be having a number of litigations. There are lots of litigations that you all seem to be fighting. There is a national draft litigation policy, and that plans to reduce the amount of litigation. How is it planning to do that?
See, practically, the government, which is a major litigant in the country, even individuals, everybody comes to the government for certain services. Of course, if within the stipulated period, if we are not able to provide the services and all that, they seek the necessary assistance from the court, they go to the court and all that. Of course, as on today, we don't have the exact number of litigations, government litigations, because various departments, various ministries, various wings, they are dealing with the cases separately and all that. Our government, after Narendra Modi came to power, where we brought an initiation called LIMS, so that each department has to upload their cases, number of cases, the stages, and in which they are dealing all these aspects. As on today, nearly 65,000 cases have been uploaded. I think many more cases need to be uploaded. It will take some time. I hope that within a short span of 3-4 months or 5 months, we will be able to get the exact figures and the stages of the cases wherein government is a litigant. We want to curtail the litigations from the government. A draft litigation policy is already under consideration of the government, wherein we want to see that there should not be a litigation between the department and departments, and certain services which you need to give to the public or persons. If you are able to deliver it in a stipulated period, and if he is satisfied, so automatically that will be reduced. If there is any confusion between the policy matters in between the government departments, then it should be taken care of. All these ideas have been brought in, and a national draft litigation policy has been formed, and it is under consideration in the Council of Ministers has been formed, and they are looking after all these issues. I hope that within a short period we will be able to see that a draft litigation policy will come, thereby a sufficient number of cases wherein government is a party, it will be certainly resolved.
Right, sir. Another important emphasis of this government has been ease of doing business. Now, India did not rank very highly in this ease of doing business index, but government has taken measures. And how important is this commercial courts, commercial divisions, commercial appellate divisions of High Courts Act 2015 in changing the whole scenario?
See, the commercial disputes, this is one of the important area where ease of doing business is concerned. The investor should have faith with the law which is in existence in that country, and if there is any disputes or something, it should be disposed of in a very short period. Timely disposal is one of the essence. So ease of doing business could be done when the investor feels that a investor friendly situation policy or laws are in existence in a country. So our Honorable Prime Minister thought that now so many persons, so many individuals, so many foreign countries are interested in invest in India. FDI, Forest Direct Investment, is also coming to our country. Under such circumstances, he wanted this one commercial dispute should be resolved at the earliest. So this commercial division in the High Court, appellate division in the High Court, this bill was passed by the Parliament, and wherein a very stringent measures have been taken with regard to the disposal of the cases. Within the stipulated period, it has to be disposed of. And experts who are well experienced in dealing with financial matters, economical studies who are done, all those persons will be placed as the judicial officer there. And even the commercial dispute of a specific value, will be dealt with exclusively by that court. And we have amended the civil procedure code also to see that certain procedural requirements which is needed, that has been taken care of. So a timely disposal of the cases will be done under that. So investor will feel that yes, this is a right law which comes in favor of me if I invest somewhere in India. So ease of doing business will be geared up by taking into consideration these aspects.
Right, so you did mention about experts. How satisfied are you with the quality of legal education in India? Are we producing enough experts in the field of law?
Of course, it's a matter that need to be looked into. Recently, we had a detailed discussion with the Bar Council chairman and other legal experts also, wherein the present situation in certain areas, there is a lack of sufficient infrastructure, faculty and other things to gear up them. Similarly, even in the stage of judicial officers and all that, we have got our judicial academies where we are training them so that they should suit to the requirements of the judicial structure across the. Now, Bar Council of India, that is the chairman who had detailed discussions, he want to see that this education should be provided in such a manner which should suit the present requirements of the world. The fast approach of our legal education is still has to be carried up. You may be knowing this today, our national law schools, they are producing very good legal experts from that schools. We have got several national schools across the country, but private law schools that need to be geared up. So they are inspecting. There is a specific committee to look after the infrastructure, look after the faculty, and look after the other requirements for to produce the good advocates or good law graduates from the university.
So what is the mandate of the 21st Law Commission?
Sir, 21st Law Commission wanted to have a very big reform, including criminal justice reform also should be there. So there are several initiatives that we have taken up in that, and several references have been made to examine the existing laws in the light of a directive principle of state policy and suggest ways of improvement and reform, and also to suggest such legislations as might be necessary for implement the directive principle of the state policy. This is one of the important areas in the preamble of the Constitution. It is there, so that has been referred. Even revise the central acts and to look after the what are the obsolete laws, redundant laws which need to be taken away from the statute book. Consider and convey the government's views on any subject relating to law and judicial administration. Consider the request for providing research to any foreign countries as may be referred by the government through the Ministry of Law and Justice. Examine the impact of globalization on food security, unemployment and other areas. So almost all the areas of reforms in judicial structure has been referred to them. Recently the Law Commission was newly formed, and they have yet to take up this issue. I hope that they will take some time. It's a very big and elaborate issue that need to have a wider consultation, and we have referred this matter to the Law Commission. We hope that they will take up this issue at the earliest and they will submit the report to the government.
This is the criminal justice system you are talking about.
Yes.
Yes. The Prime Minister has time and again said that we need to do away with old and obsolete laws, and you mentioned that also as part of the mandate of the Law Commission. What is the current status as far as this is concerned, sir?
Honorable Prime Minister has formed a two-man committee at the initial stage itself and identified as many as 1,827 enactments which is obsolete and redundant that has to be repealed. So the government took an initiative, and so far 4 bills have been placed. We have almost all repealed 1,075 obsolete laws from the statute book. Prime Minister telling that every day we should remove one obsolete laws from the statute. Now it is more than that. Out of 1,827, about 200 odd that need to be repealed by the state government. and about 427 that we have to take care of. Rest everything is taken care of. We have written to the government, state governments, after the 42nd constitutional amendment. Certain enactments passed by the parliament during the president's rules in the concerned state. Earlier, it used to be repealed by the central government. Now, the state government has got right. So, we have identified all those repealing acts, and we have written to the state government also, and nearly 427 acts we have to repeal. We are working on it. We hope that in the next session we may move another 1 or 2 bills so that we can repeal the.
So one of the big issues that is in our country is that a large number of cases are pending. What are the steps that government has taken apart from this, taking away obsolete and old laws, to reduce the pendency in courts?
See, the total disposal of the cases, that is absolutely on the domain of the judiciary. This is the responsibility of the governments to give them proper infrastructure facilities and cooperate what all things, especially nowadays every day we are hearing about the appointment of judges. There is lack of judge strength and all that. Of course, there is a shortage of judges. It could not be appointed because of the National Judicial Appointment Committee was under challenge. During that tenure, we could not able to do that. But the collegium has to give the list of the names that has to be elevated to the High Court or Supreme Court. The government's responsibility is to process it, to get the IB report, right to the constitutional authority, that is chief minister and the governors of the state, and get the feedback, and we have to do it. That is the responsibility of the government. But as on today, we have seen, I can give you the statistics of course there is a huge pendency, I don't dispute that, but the government is doing all necessary support to reduce the. See, we have providing financial assistance for infrastructure development. So far in the last 5 years, 3,694 crores was allotted to the states and the union territories for the infrastructure to the subordinate courts. For example, I will tell you infrastructure is sufficient. At present, we have got about 16,513 court halls in the subordinate judiciary, as against the working strength of 16,070. And nearly 2,447 court halls are under construction for the future requirements. We have taken up the initiatives to enhance the sanction strength of the subordinate judiciary, which has been enhanced from 17,715 by the end of 2012. Now it has been 20,502 in 2015. The sanction strength of the High Court, which has increased from increased to 1,065 as on 19/5/2006, as against 906 in March 2014. The government has taken up the matter with the High Court in filling up of the vacancies, because the vacancies of the subordinate courts has to be filled up by the state government in consultation with the High Courts. So we are repeatedly writing the state government, we are doing it. Even we have taken up the issues for speedy disposal. The one is Lok Adalat, wherein several cases are being disposed of out of court settlements. We are going to do that. Commercial courts, commercial division and commercial appellate division, that has also geared up. Because of that, speedy disposals will be there. Even in Delhi, Delhi High Court Amendment Act, wherein the pecuniary jurisdiction of the Delhi subordinate courts have been enhanced from 20 lakhs to 2 crores, so that all the cases which have accumulated there in the High Court has been divided and taken over by the subordinate courts, so it can be disposed of. So these are the areas where we have taken initiatives to see that speedy disposals of the cases should be there.
You're watching an interview with the Law and Justice Minister, Mr. Sadananda Gowda. We are going to take a short break. Do stay with us.
ये साइड से थोड़े छोटे कर दे जल्दी।
ये वाला सर?
क्या ये?
सर ये साइड से?
नहीं नोज पियर्सिंग यहाँ पे
परफेक्ट हो जाएगा मैम।
बिल्कुल दर्द नहीं होगा।
पता भी नहीं चलेगा आपको।
कुछ ऐसा ही करते हैं आप अपने गियरलेस स्कूटर के साथ। गियरलेस स्कूटर में कोई भी 40 ऑयल नहीं, सिर्फ सर्वो स्कूटोमैटिक 4ST ही डालिए। इसके फ्रिक्शन मॉडिफायर्स इंजन की परफॉर्मेंस बढ़ाए और आपकी राइड स्मूदर बनाए। सर्वो स्कूटोमैटिक 4ST।
सुनो सुनो किसान भाइयों, सुनो सुनो, ओ सुनो सुनो किसान भाइयों, सुनो सुनो, सुनो सुनो किसान भाइयों, ध्यान लगाकर बात सुनो। नीम कोटेड यूरिया आया, खेती में नई क्रांति लाया। इससे यूरिया की क्षमता और बढ़े, नाइट्रोजन जमीन को बेहतर मिले, नीम के गुणों से कीटाणु मरे, पानी को दूषित ना करे। तो भाइयों, नीम कोटेड यूरिया से हो मेहनत सफल, बेहतर हो खेत, पानी और फसल।
कृषि और किसान कल्याण मंत्रालय द्वारा किसान हित में जारी।
Welcome back. So before the break, you were talking about how we all have the government has increased the infrastructure strength, also working towards, filling in judges. The problem that perhaps there were a shortage of judges. In terms of the capacity of courts, are they functioning to their full capacity, sir? In terms of infrastructure.
Sir, at present we have provided more infrastructure. At present the court halls are more, whereas the working judges, their strength is less. Of course, we have already enhanced the sanction strength. It is the responsibility of the state government to fill up the vacancies after due consultation with the High Court. For the subordinate courts, we have already enhanced the strength. Even the Supreme Court Collegium has to fill up the vacancies here. And in the High Court Chief Justice and his colleagues who are in the Collegium, they have to send the list to process it through Supreme Court to the Ministry of Law and Justice. We are taking care of all those things. If I am right, I think that just because judges' strength alone is not the criteria for in pendency of the cases. Of course, 40% vacancy in high courts and about 25% vacancies in the subordinate courts. But you can see since last 2-3 years, the pendency in Supreme Court of India has been declined from 66,619 two cases at the end of the year 2012 to 59,468 cases in 19 to 2016. Even though there is a there was a vacancy of about 6 vacancies were there. Now 4 has been filled up recently. I would like to place it on record. The process for appointment of 4 Supreme Court judges was completed by the Ministry of Law and Justice within a short period of 6 working days. Within a short period. So, usually as soon as the name comes to us, we are processing it and we are clearing the things. The pendency in High Court has been declined from 42.49 lakhs to 38.70 lakhs as on 31/12/2015. Even the district court also 2.70 crores cases are pending at present as against 2.77 crores in 2010. So, there is a reduction in pendency, even though there is a vacancy of judges, but filling up of vacancy of judges will certainly gear up, and we hope that it will give more and more disposals at the earliest.
So one of the big issues that we face in our legal system is that the cost of legal aid itself is so expensive. I mean, the common man, it's outside the reach of the common man. What extent is the government helping, in addressing this kind of situation, making it affordable?
See, there is a National Legal Service Authority which has been constituted under the Legal Service Authority Act of 1987. So, in various stages, right from Supreme Court up to the lower district court, there are various legal service authority committees. They will take care of these issues. Who are in need of legal service, they will be provided this legal service everywhere. And this has taken much initiation in resolving the cases also. We give legal assistance to the persons when the matter goes to the Loka Adalat. A poor person who needs some legal assistance, he will be provided with this. And this is being supervised by the National Legal Services Authority, which is headed by the Supreme Court judge. and in the High Court judge and the District Court judge, they are supervising all these activities, and all the persons who need the legal aid, they will be provided legal aid services under NALSA.
So one way also of bringing down the costs is probably by infrastructure in terms of ICT. You know, we are in the age of digital India. This is one of the flagship programs of the government. In terms of e-courts, they have started functioning. How effective are they, sir, in dealing with these kind of issues?
It is one of the major initiations, and Honorable Prime Minister is very much eager to see that this technology should be adopted in each and every area. Certainly it will favor for disposal also. The total e-court mission mode project, the first phase is completed. Nearly more than 16,000 courts have been already computerized. Subordinate courts are already computerized. And phase 2 e-court project, the cabinet has given a sanction for the second phase, wherein about 2,000 and odd new courts, 5,000 and odd new courts, they will also be computerized, and the necessary things that need to be taken care of in the first stage of the computerization, that also will be taken care of at the cost of 1,670 crores. Now the phase 2 has also begun, and we are linking everything with national data grid. Once it is linked with national data grid, anybody can go through the site. He can see what exactly the position of the station, dependency and other things. We want to, in the second phase, all e-filing, e-payments, everything should be done through the e-court management system. So if we are able to complete this project at the earliest, we have to complete it by 4 years. We are thinking that we are planning to complete it within a short span of 3 years, so that once that is done, the case stages, cost lists, everything will be available to the litigant, and it will be easier for the advocate or the lawyer to identify, easier to manage for the judge what is dependency and how it goes and all that. At present, nearly more than 6 crore cases disposed and pending cases, they have been already brought under National Judicial Data Grid, and nearly 2.5 crore judgments have been are available on the National Data Grid. This will give a new direction to the whole legal system in future.
So even the Chief Justice of India suggested that you utilize retired judges to help with the pendency of cases. How do you view this suggestion?
We are certainly, I do concede, and even I myself wrote a letter to the former Chief Justice as early as in the month of September. You take assistance of retired judges to speedy disposal of the cases. But unfortunately, there was one observation by one of the former Chief Justices, that unless the vacancies are filled, it is not fair to go for the appointment of the judges, retired judges. But we are already written to the Chief Justice. Even at this stage, if they certainly feel that it should be taken, government is ready to concur with the views of the Chief Justice.
So what is the roadmap of the Ministry of Law and Justice for the next 3 years?
This pendency of the cases, disposal of the cases, that is one of the important areas we should take care of. What all assistance that need to be given, certainly we are giving importance to that. Apart from that, we have got the infrastructure has to be improved. Improving infrastructure to the subordinate judiciary, that is one of reduction of arrears and ensuring the speedy disposal, reforming of the court procedures and processes. This is one of the important area that we have to take care of. The filling up of the vacancies after due consultation, after taking the suggestions of the states and other things, that is also strengthening the legal aid services. This area we have traversed too much. Now certain areas in the northeastern region and in Jammu and Kashmir, we are giving this enhancing ICT enabled courts, utilization of grants sanctioned by the 14th Finance Commission, because in the 13th Finance Commission we could not able to spend everything. So this one, entry of foreign lawyers and law firms to India on reciprocal basis, and implementation of Law Commission's report, that 244 and 254 reports containing various recommendations on electoral reforms. That is one of the important areas that we need to cover. We have to revamp the entire electoral arena also. These are the several challenges we are facing, and I hope that the initiation taken by the Honorable Prime Minister since last 2 years, as far as this judicial sector is concerned, it is really has taken geared up ease of doing business and repealing the redundant and absolute laws, and giving legal aid to the poor persons, giving more response to the ICT enabled this one e-court management system and other things. All these things have been geared up to a considerable extent. We hope that what all the targets that we are aiming at, that we will be able to complete within 3 years of the remaining period with our government.
So you've mentioned about ease of doing business once again, and well, the commercial courts have started functioning, but the CJI has criticized the decision depending on the existing manpower. It says there's not enough manpower and infrastructure. Now, how does the government plan to, bring in, let's say, help corporate clients understand and make it really functional?
I don't want to enter into the domain of the judiciary. Independent of judiciary is never encroached upon by the legislature so far. So we don't want to do that also. As soon as the names are from the collegium comes to us, we will processing it at the earliest. At present, you can I will give one example. Last year, National Judicial Appointment Committee, it was under challenge before the Supreme Court. So during that period, we could not fill up any vacancies. Earlier that, from January to March, to the best of my knowledge, 2015, we have appointed about 30-35 judges. But this year, the government thought that, even though government was told by the Supreme Court that the memorandum procedure has to be relooked into, there are certain areas where some more transparency in appointments, and as far as secretariat and other enquiry matters are concerned, some reforms need to be brought in the memorandum procedure. So we have been asked to give a draft memorandum procedure. We have given the draft memorandum procedure to this CJ. We are awaiting the papers from him. But I myself went to the Chief Justice, and the government said, sir, the new memorandum procedure, it will take some time. So there will be a huge pendency. For that reason, we can go ahead with the appointment of judges as per the earlier memorandum procedure till the new memorandum procedure is finalized. So we cooperated. This year, from January to this till the mid of May, we are able to appoint 51 judges, and we are able to make 87 judges permanent. So this shows that we have taken how much speed we have taken. Now nearly 170 names which are recommended by the collegium is with us. We are processing this so fast. We hope that as soon as we get the observations from the chief ministers and the governors and IB reports, we are processing it. So we hope that we are faster than ever, and we will be faster in future also.
So in your roadmap, you did also mention about foreign lawyers. Now, many people consider this a contentious issue. Could you just clarify what you actually mean as part of the roadmap for foreign lawyers?
Earlier in the Advocates Act and other laws prevailing in this, no lawyer and firms could be able to take part in Indian judicial system. Now, it is a fast-growing world, and so many foreign investments are coming in, and so many investments we are making somewhere outside and all that. So it is the need of the hour that foreign legal firms reciprocally should come, and our law firms should practice in somewhere outside the country and all that. So we had discussions with the Bar Council chairman. It comes under the dominion of the Bar Council of India, and there is a matter pending before the Supreme Court also. So talking too much about that matter, it amounts to sub judice also. But we are working on it. Already Bar Council chairman has made a visit to a few countries like UK, USA, and even Australia and all that. We are working on it. Within a short period, we are able to see that foreign law firms reciprocally we will have our practices both here and in foreign countries.
Law and Justice Minister Mr. Sadananda Gowda, thank you very much for talking to us on DD News. Thank you, sir.